Welcome back, future solicitors. We have finally at the tail of our journey to understand negligence in tort, the part everyone secretly wants to hear about money. How much money or damages my client or I will get. Yes, damages, the part where law turns wrongdoing into numbers, into money. But before we start imagining instant payout and champagne celebrations, remember this golden rule: tort restores, it does not reward. The purpose of tort is to put the party where they were before tort happened. Our job today is to understand what the court actually means by compensation, how they calculate it, and why you will never walk away from a negligence claim with a golden check of emotional trauma and mild inconvenience. Sorry to disappoint. So, purpose of remedies. Let's start with philosophy behind it all. Remedies in tort are about balance, restoring the claimant to the position where they were before the tort occurred. Think of it as legal time travel without the fun or the flux capacitor. The idea is fairness, not profit. You should be made whole, not better off. So, if you dent my car, I get the cost of repair, not a brand new Tesla. Punitive damages, they exist, but in negligence, they are rarer than a student who read the SQ syllabus just for fun. Tort isn't there to punish. There is criminal law's job to punish people. Our job is to restore equilibrium. So, types of damages. Now let's meet the cost. The five main types of damages you need to recognize for the SQE. So the first up, general damages. These cover things that cannot be neatly calculated, like pain, suffering, and loss of enjoyment. There is no spreadsheet for heartbreak or a broken ankle. Judges make reasoned estimate for that or compensation for that. Then there are special damages. The accountant's favorite. These are measurable financial losses, medical bills, repair costs, loss of earning. Think receipts, invoices, and bank statement whatsoever a person has lost. Next is nominal damages. These are symbolic. You win the case but get £1. Congratulations on your moral victory, plus kind of nominal damages. You were technically right, but the universe remains unimpressed. Then come aggravated damages, which recognize the extra hurt caused by the defendant's behavior, maybe humiliation or insult. The classic example is when the defendant acted like a complete prat during the tort or after it, or aggravated its own action at some point. So finally, there are exemplary damages. These are designed to punish outrageous conduct. But remember, they are almost never awarded in negligence. If you see them in an exam scenario, your first instinct should be unlikely that it won't happen. Tort does not punish people. It puts them on a position where they were, unless and until it is an extraordinary act which will meet an extraordinary damages. So the next one is assessing compensatory damages. Now, how do court actually decide how much to award? Their guiding star is full and fair compensation. Not generous, not stingy. They need to keep it fair. So damages are usually assessed as of the date of judgment, for example. not the date of the tort. And court considers things like actual financial losses or future financial losses of earning, for example, medical and care cost, and of course, pain and loss of amenity. That's the loss of enjoyment of life, like not being able to play tennis, football, doing garden, or dance like you used to. A key case here is Wells versus Wells. That's very important from 1999, where the House of Lords said future losses must be discounted using sensible investment rates because claimants invest their damages, they do not store them under the mattress. So, next time you calculate damages, remember the court are not running a lottery, they are performing financial CPR. So, the next thing we need to understand is mitigation and multiple defendants in one tort. This is where things are practically chaotic. The claimant has duty to mitigate their loss. That means taking reasonable steps to reduce the harm. You can't sit at home, just watch Netflix and let your losses pile up, hoping for a bigger payout when you had an opportunity to mitigate them. The law expects you to act reasonably and responsibly. For example, if your employer's negligence injures you, you must seek medical help or alternative work as soon as it's reasonable. If you refuse and make things worse, your damages will be reduced. Now, what happens when there is more than one wrongdoers for the same tort? The joy of shared blame. When multiple defendants are liable, they can be jointly or severally responsible. That means the claimant can recover all damages from one defendant. Yes, one unlucky one. That might be rich. So, who can then chase the other for contribution later? Making things a bit complex, but this is how it works in tort. So, imagine three friends recklessly pushing a car downhill. It rolls away and causes damage. The claimant can sue any one of them, maybe the son of a rich man, for the full amount. Moral of the story: never join group stupidity. Liability multiplies faster than laughter. So, to look at SQE, that what we need to look at once you need to choose between damages. In SQE, you will not be asked to calculate damages like an accountant. Thanks to God. But you will be tested on your understanding of how damages are categorized and justified. So here is your mental checklist. Identify the type of loss, physical, financial, or emotional. Match it to appropriate type, general, special. Watch for mitigation or contributory negligence kind of clues. They always hide in the facts. And finally, of course, check whether the damages are restoring or rewarding. Common traps. Students often confuse general with special damages and assume exemplary damages are normal. No, they are not. If you see a question suggesting a large punitive award in negligence, that's your red flag. Only John Grisham's novels, they talk about these kind of things, that a company was punished with a big fine. It does not work in court or in tort. So your golden exam question should always be: has the claimant been fully but not excessively compensated? If your answer is yes, you are right on target. And there we have it, remedies and damages, the grand finale of negligence. We started with duty, breach, and damages, and we finish with the number one question client care about: how much am I getting out of it? But remember, tort law's beauty lies in the balance. The balance it got inside. It is not about revenge, it is about fairness. It is society's way of saying we cannot undo the harm, but we can make it right. So, as you prepare for SQE1, keep that spirit in mind. Law is not just rules and Latin phrases that we sometimes I can't pronounce. A system built on fairness, reason, and pinch of common sense. Next time, we will explore how the principle connects different tort and how to handle mixed problem questions and different other things that we need to take care of in our tort law SQE exam. So, next chapter, we will discuss occupier's liability. So, see you soon. Thank you for watching and listening SQE 1 window.